Chairman, I want to thank you for holding this hearing in the open, in full view of the American people where it belongs. I believe the American people have had it with stonewalling. Americans don't want to hear that answers to relevant questions are privileged and off limits, or that they can't be provided in public, or that it would be, quote, inappropriate for witnesses to tell us what they know. We are talking about an attack on our democratic institutions, and stonewalling of any kind is unacceptable. And General Sessions has acknowledged that there is no legal basis for this stonewalling. So now to questions. Last Thursday, I asked former Director Comey about the FBI's interactions with you, General Sessions, prior to your stepping aside from the Russian investigation. Mr. Comey said that your continued engagement with the Russian investigation was, quote, problematic, and he, Mr. Comey, could not discuss it in public. Mr. Comey also said that FBI personnel had been calling for you to step aside from the investigation at least 2 weeks before you finally did so. Now, in your prepared statement, you stated you received only, quote, limited information necessary to inform your recusal decision. But given Director Comey's statement, we need to know what that was. Were you aware of any concerns at the FBI or elsewhere in government about your contacts with the Russians or any other matters relevant to whether you should step aside from the Russian investigation?
Senator Wyden, I am not stonewalling. I am following the historic policies of the Department of Justice. You don't walk into any hearing or committee meeting and reveal confidential communications with the President of the United States, who's entitled to receive confidential communications in your best judgment about a host of issues, and have to be accused of stonewalling for not answering them. So I would push back on that. Secondly, Mr. Comey, perhaps he didn't know, but I basically recused myself the first day I got into the office because I never accessed files. I never learned the names of investigators. I never met with them. I never asked for any documentation. The documentation, what little I received, was mostly already in the media and was presented by the senior ethics, public responsibility, professional responsibility attorney in the department. And I made an honest and proper decision to recuse myself, as I told Senator Feinstein and the members of the committee I would do when they confirmed me.
General Sessions, respectfully, you're not answering the question.
Well, what is the question?
The question is, Mr. Comey said that there were matters with respect to the recusal that were problematic and he couldn't talk about them. What are they?
Why don't you tell me? There are none, Senator Wyden. There are none. I can tell you that for absolute certainty. This is a secret innuendo being leaked out there about me, and I don't appreciate it. And I've tried to give my best and truthful answers to any committee I've appeared before, and it's really people are suggesting through innuendo that I have been not honest about matters, and I've tried to be honest.
My time is short. You've made your point that you think Mr. Comey is engaging in innuendo. We're going to keep digging on this.
Well, Senator Wyden, he did not say that.
He said it was problematic, and I asked you what was problematic about it.
Some of that leaked out of the committee that he said in closed sessions.
Okay. One more question. I asked former FBI director whether your role in firing him violated your recusal, given that President Trump said he fired Comey because of the Russian investigation. Director Comey said this was a reasonable question. So I want to ask you just point blank, why did you sign the letter recommending the firing of Director Comey when it violated your recusal?
It did not violate my recusal. It did not violate my recusal. That would be the answer to that. And the letter that I signed represented my views that had been formulated for some time.
Mr. Chairman, just if I can finish, that answer, in my view, doesn't pass the smell test. The president tweeted repeatedly about his anger at investigations into his associates in Russia. The day before you wrote your letter, he tweeted that the collusion story was a total hoax and asked, when will this taxpayer-funded charade end? I don't think your answer passes the smell test.
Well, Senator Wyden, I think I should be allowed to briefly respond at least, and would say the letter, the memorandum that Deputy Rosenstein wrote, and my letter that accompanied it, represented my views of the situation.
Senator Heinrich.
Attorney General Sessions, has the President ever expressed his frustration to you regarding your decision to recuse yourself?
Senator Heinrich, I'm not able to share with this committee private communications.
Because you're invoking executive privilege.
I'm not able to invoke executive privilege. That's the President's prerogative.
Well, my understanding is that you took an oath, you raised your right hand here today, and you said that you would solemnly swear to tell the truth, the whole truth, and nothing but the truth. And now you're not answering questions. You're impeding this investigation. So my understanding of the legal standard is that you either answer the question, that's the best outcome. You say, this is classified, can't answer it here. I'll answer it in closed session. That's bucket number 2. Bucket number 3 is to say, I'm invoking executive privilege. There is no appropriateness bucket. It is not a legal standard. Can you tell me what are these long-standing DOJ rules that protect conversations made in the executive without invoking executive privilege?
Senator, I'm protecting the President's constitutional right by not giving it away before he has a chance to
You're having
review
it
it.
both
And
ways.
secondly, I am telling the truth in answering your question in saying it's a long-standing policy of the Department of Justice.
Are those
not
policies
to comment,
written?
even and to make sure the President has full opportunity to decide these issues.
Can you share those policies with us? Are
Well,
they written down at the Department of Justice?
I believe they are.
This is the appropriateness legal standard for not answering congressional inquiries.
It's the my judgment that it would be inappropriate for me to answer and reveal private conversations with the President when he has not had a full opportunity to review the questions and to make a decision on whether or not to approve such an answer. One, there are also other privileges that could be invoked. One of the things deals with the investigation of the special counsel as
And
other.
we're not asking
Well,
questions about that investigation. If I wanted to ask questions about that investigation, I'd ask those of Rod Rosenstein. I'm asking about your personal knowledge from this committee, which has a constitutional obligation to get to the bottom of this. There are 2 investigations here. There is a special counsel investigation. There is also a congressional investigation. And you are obstructing that congressional investigation by not answering these questions. And I think your silence, like the silence of Director Coates, like the silence of Admiral Rogers, speaks volumes.
I would say that I have consulted with senior career attorneys in the department,
I suspect
and they believe
you have.
this is consistent with my duties.
Senator Risch asked you a question about appropriateness. If you had known that there had been anything untoward with regard to Russia and the campaign, would you have headed for the exits? Your response was maybe. Why wasn't it a simple yes?
Well, there was a improper, illegal relationship in an effort to impede or influence this campaign, I absolutely would have departed.
I think that's a good answer. I'm not sure why it wasn't the answer in the first place. I find it strange that neither you nor Deputy Attorney General Rod Rosenstein brought up performance issues with Director Comey. And in fact, Deputy FBI Director McCabe has directly refuted any assertion that there were performance issues. This is troubling because it appears that the President decided to fire Director Comey because he was pursuing the Russia investigation and had asked you to come up with an excuse. When your assessment of Director Comey didn't hold up to public scrutiny, the President finally admitted that he had fired Director Comey because he was pursuing the Russia investigation, i.e. the Lester Holt interview. You've claimed that you did not break recusal when participating in Director Comey's firing, but it appears that his firing was directly related to Russia, not departmental mismanagement. How do you square those two things?
Well, you had a lot in that question. Let me say first, within a week or so, I believe May 3rd, Director Comey testified that he believed the handling of the Clinton declination was proper and appropriate, and he would do it again. I know that was a great concern to both of us because it did not, that represented something that I think most professionals in the Department of Justice would totally agree, that the FBI investigative agency does not decide whether to prosecute or decline criminal cases. Pretty breathtaking usurpation of the responsibility of the Attorney General. So that's how we felt. That was sort of additional concern that we had heading the FBI, someone who boldly asserted the right to continue to make such decisions. That was one of the things we discussed. That was in the memorandum, I believe, and it was also an important factor for us.